The next bill up is Representative Mahler, House File 3391. There is a small fiscal note on this. So this is the final bill we have up today, modifying and modernizing certain provisions governing guardianship and conservatorship. Representative Mahler moves that House File 3391 be re-referred to Ways and Means. And we have a DE1 amendment. Representative Mahler, would you like to make the motion for that DE1 amendment to put the
So moved, Mr. Chair.
The DE1 amendment has been moved. Any discussion? All in favor of the DE1 amendment signify by saying aye. Aye. All opposed say no. Motion passes. The DE1 is adopted. And Representative Mahler, to your bill as amended.
Thank you, Mr. Chair and members. For nearly 2 years, a coalition of attorneys, advocates, guardians, and many other stakeholders gathered to closely examine Minnesota's guardianship and conservatorship laws with the goal of modernizing them. And you'll see in your packet some handouts that have some of those groups that were involved in this bill. This bill incorporates the comprehensive recommendations from that coalition while also building upon many recommendations from the Uniform Law Commission's 2017 updated model guardianship law. This bill seeks to reduce unnecessary guardianships and conservatorships, promote less restrictive alternatives, and clarify multiple parts of the law that conflict with current best practices. More specifically, the bill makes changes to definitions and defines important terms such as supported decision-making for the first time. It requires petitions and orders for guardianship to detail why less restrictive alternatives cannot work. It narrows the reasons a guardian can restrict access to visitors. It updates the Guardianship Bill of Rights, clarifies how certain notices must be given, requires time-limited guardianships for people under 30. It provides better safeguards for medical and financial privacy of persons being put through guardianship proceedings. Many of the provisions of this bill are the result of thoughtful debate and compromise from stakeholders who often have different views of the guardianship and conservatorship system, but who all believe these changes will make the system better for thousands of Minnesota. And with that, Mr. Chair, I would like to introduce my testifiers.
Thank you. Please introduce yourself for the record and begin your testimony.
Mr. Chair and members of the committee, my name is Darcy Rossborough. I'm the parent of a 19-year-old son whose name is Eric. He has epilepsy, high-functioning autism, and a number of other diagnoses that keep our life very interesting at all times. I'm privileged to provide testimony in support of this very important bill. Our family first learned about supported decision-making from an attorney that I was consulting about guardianship several years ago. I have been told and reminded many, many times through our healthcare providers, mental health providers, and the school system that I needed to make sure I got guardianship in place for Eric by the time he turned 18. When this attorney described supported decision-making to me, I knew we found a much better fit for our situation. As Eric's supporters, we help him make crucial decisions, and we have a process in place to do that. We're not his guardians. When Eric has a decision to make he needs help with, he talks to either myself or his aunts or his uncles that are all part of his supported decision-making team. And we walk through what he's saying, and we make sure that we help him make a good decision. A specific example of this is that Eric was in a post-secondary transition program for ages 18 to 21 this past fall. And it turned out that Eric felt he was ready to go ahead and be done with this program, take his diploma and move on. And his teachers disagreed with that. Through the supported decision-making process, we had a great conversation about his life goals in general, moving on into an apartment with roommates, getting ready for the organization skills, life skills, and the financial skills that he was going to need to be able to live independently and create a path toward that. With that in mind, he ultimately came to the decision on his own that he was ready to be done with school, acquired his diploma, and finished up. So that we are in great shape with right now. I'm sorry, I didn't get my notes down here. So Eric couldn't be with us here today because luckily he's at work. He's at Devani's this morning, and I asked Eric what he would want to tell you. He uses supported decision-making to help think through decisions, like what jobs to investigate as part of his vocational rehab service program, or whether or not to get his wisdom teeth surgery now or later. He says, because of the supported decision-making, I make my own decisions, which, trust me, is very important to him. We strongly support this bill as it will help others who have this important opportunity. Thank you.
Thank you very much for your testimony, Ms. Rossborough. We're going to wait on questions from the committees until we hear other testifiers, too. So thank you. You can stick around for questions. And you have another testifier, Representative Muller?
Yep, that's correct, Mr. Chair. I've got two testifiers here, and I will let them introduce themselves with your permission.
Welcome. Please introduce yourself.
Thank you. Mr. Chair and members of the committee, my name is Mary Hoff. Together with my daughter Jean, we are privileged to provide testimony in support of this important bill. Our family first learned about supported decision-making from Jonathan Martinez, an expert in disability law issues, several years before Jean turned 18. And his presentation solidified for me that supported decision-making was a great alternative to a court-ordered guardianship that we know some of her older peers and classmates have. Our parenting decisions and expectations have always been for Jean to become an independent adult, and Jean has grown up with her own expectations of living as independent life as possible. Like all young adults, Jean is growing and developing her own decision-making skills. We are right-sizing our supports, giving her the freedom and choice to live her life. As Jean supporters, we help her make crucial decisions, and we have a process to do that. The way it works is when a decision comes up, Jean either decides on her own or she goes over the issue with us. We review information and choices together and discuss options and consequences of her different choices. We're not her guardians, as she does not need someone else to determine how to live her life. In addition, I have also been utilizing supported decision-making principles to support my 89-year-old mother, Joanne. My siblings and I have helped her through a number of complicated health issues, including her most recent struggle with mixed dementia. As her memory loss has progressed, we have increased our support and assistance with decision-making. We strive to respect her wishes, helping her age with dignity, retaining a balance of safety and autonomy, and preparing for the next phase of her life without removing her civil rights through a guardianship. Not only are we her children, we are her advocates. No matter a person's stage in life, whether their capacity is growing or diminishing, they should have access to individualized, natural supports that help them live with dignity, autonomy, and self-determination. That is why we strongly support the many changes proposed in House File 3391 and hope you will as well.
Very much for your testimony, Ms. Hoff. Welcome to the committee. Please introduce yourself.
Mr. Chair and members, my name is Jean Hoff. Thank you for the chance to provide my testimony. Personal Senate planning has helped me with my goals and life plans. I am making my own decision to go to college, have a career, and live independently. Just before my 18th birthday, my parents and I talked about the need to have legal documents in place. Since I was going to become an adult, they helped me find a lawyer. I meet with John Cocky at VOA. I was comfortable with him as my lawyer. We worked together to create my legal documents, a healthcare directive and power of attorney with specialist protection and support decision-making agreement. John reviewed my documents with me before I signed them. My parents were at the meeting as my supporters. The process was not hard or scary. I felt empowered. I did not have to go to court. A judge has not taken away my right to make decisions about my life. I do need some support making healthcare decisions. My mom goes to my appointments with me helps me express things and make decisions. I have had same doctors my whole life, so I have good doctors, patients, and relationships. I am learning to do my budgeting and baking. My mom is putting me as a nurse and takes more responsibility. Thank you for this opportunity, as I think everyone deserves a chance to set up split decision making for their own life.
Thank you very much for your testimony, Ms. Hoff. An excellent job. Very nice. Are there questions from members of the committee for, well, actually, I should ask, do we have another testifier first? Oh, 2 more testifiers. Well, let's hold off on questions then until we get through the other testifiers. Welcome to the committee. Please introduce yourself and begin your testimony.
Mr. Chair, members, my name is Sean Burke. I'm the Public Policy Director with the Minnesota Elder Justice Center. As Representative Moeller said in her remarks, this bill represents nearly 2 years' worth of collaborative stakeholder involvement, a process that was really spearheaded by Bob McLeod here to my left. Our organization often works with vulnerable and older adults for whom guardianship is not working or it's not a good option in the first place. Without Bob's efforts and the cooperation and agreement with the large stakeholder, with all the stakeholders, it's doubtful that we would have this significant piece of legislation. Together, Bob and I are going to highlight the key changes to guardianship and conservatorship law in the DE amendment. We'll do our best to direct you to the section and the line number. So starting in section 1, at line 1.10, you will notice that currently Minnesota law does not allow judges to order mediation in guardianship cases, but in many situations, mediation can be a critical tool to resolving disputes in guardianship litigation, especially when there is a dispute as to whether guardianship should even exist or who should be the guardian. This change would allow courts to order parties to mediate. Sections 2 through 9 include new definitions that will help clarify critical parts of guardianship cases and proceedings. At the heart of every guardianship case, a court must make 2 findings in order to order a guardianship. It must do so by clear and convincing evidence. The first is it must find that the person is incapacitated. The second is that it must find that there are no less restrictive alternatives. The definition in section 3 at line 1.17 modernizes the definition of incapacitated person to include a less restrictive analysis. And this is because capacity for purposes of guardianship is different than, say, informed consent for a medical procedure. And before removing a person's civil rights, a court must be sure that no less restrictive alternatives exist. The addition on line 1.22 will help ensure that that happens. Moving to section 9, line 3.22, you will see for the first time in Minnesota law, we will have a definition of supported decision-making, a specific type of less restrictive alternative. Earlier, you heard the testimony from Jean and others who've established a supported decision-making agreement and has supports in place to help her. The language in this definition comes specifically from the Uniform Law Commission and their model guardianship statute in 2017. It provides a broad understanding of supported decision-making so that a wide array of supported decision-making agreements, including those that you heard about in Eric and Jean's testimony, will be recognized by this definition. Turning now to section 13, starting on line 7.11. This is the Bill of Rights for persons under guardianship. For many guardians and people under guardianship, one of the most difficult situations that can arise is a disagreement about who the person under guardianship can communicate with or interact with. Currently, under Minnesota law, guardians have a wide leeway and latitude to restrict the rights of persons under guardianship from speaking, calling, texting, or otherwise communicating with other persons. This important change, which is also modeled after the Uniform Law Commission provisions, instructs guardians to only restrict those communications when 1, there is a risk of significant harm, and 2, there are no other alternatives to prevent the risk. Additionally, the guardian must notify the court, the person under guardianship, and the person from whom the person under guardianship is being restricted. The person under guardianship can then petition to have the court modify or lift the restriction.
Mr. Chair and members.
Before you begin, Mr. McLeod, Mr. Burke, can you tell me how often do you run into scenarios where mediation should be ordered, but judges just don't do it?
Mr. Chair, again, my name is Robert McLeod, Bess and Flanagan. Most cases, as a simple, most contested cases, let me say most contested cases. Now, the simple fact is by statute, they can't order mediation. And that's why we're changing the statute. They are not allowed to, although Hennepin
The
County.
statute specifically prohibits that.
Yes,
Okay, thank you. Go ahead with your testimony.
thank you. Starting in section 14, line 8.1 and through the rest of page 8 is a new section called the Bill of Particulars. The purpose of this addition is to better protect the privacy rights of persons for whom a guardianship is being considered. When a petitioner begins a guardianship case, as Sean said, they must prove incapacity. That means proving that the case often involves medical information and medical records about a person's diagnosis and oftentimes intimate and private details about their everyday needs. While parties can request to file such document confidentially, the reality is not all courts allow such requests. And in fact, if you look at the court website, it says you can't. This section establishes a new process called the Bill of Particulars, a form that the parties attach medical records and other private data and file it confidentially. In addition to this new section of the law, throughout the bill is additional language that directs parties or others filing information with the court exactly when to use this process. One example is on line 9.18, which indicates what type of documents need to be filed confidentially, consistently with the Bill of Particulars procedure. This language is repeated throughout the bill to clarify when certain documents in guardianship conservatorship process need to be filed in a way to protect privacy. This change is critical in protecting private information, especially as we near the day when Minnesota court files records. The records will be filed publicly with just a click. You can just sign on and click and see everyone's pleadings right there on the internet.
Moving ahead to section 17 and section 20, starting on line 11.
Go ahead, Mr. Burke.
Oh, sorry. Starting on line 11.27, petitioners bringing a case alleging guardianship is necessary will need to describe any less restrictive alternatives that have been attempted. This is right in line with the second prong of finding a guardianship. And it corresponds with section 20 on line 16.6, whereby after the petition and the litigation, a court, in making a finding, in order to place a person under guardianship, will now need to make specific findings as to why supported decision-making or other alternatives do not work. Staying on page 16, at lines 16.20 to 16.26, this bill introduces a new tool to help reduce unnecessary guardianships. If a person is under the age of 30 when a guardianship is established, that guardianship will end after 6 years. A new petition can be filed at that time if it is still alleged that the person is incapacitated and no less restrictive alternatives will work. We know that too often families of young adults are directed to use guardianship as the only legal mechanism to protect a young adult. The testimony you heard earlier belies that notion. We also know that critical development happens for all persons, especially those with intellectual and developmental disabilities in their young and mid-20s. This mechanism simply allows the system to pause and really examine if a guardianship is needed.
Again,
Mr.
Robert.
McLeod.
Oh, thank you, Mr. Chair. Again, Robert McLeod. In section 21, starting at line 17.32, there's an important clarifying change to the emergency guardianship process. Too often in Minnesota, the emergency guardianship is not being used for its intended purpose. An emergency guardianship is a proceeding that lacks sufficient due process for the person who is alleged to need a guardian. It is designed for extreme cases only. Unfortunately, many courts overuse the tool and allow for multiple extensions of the emergency guardianship. The result is that a person can wait months on end, sometimes longer, without receiving the full due process protections of a full guardianship hearing. This language clarifies that emergency guardianships can only be extended one time, so that the total maximum time anyone under an emergency guardianship order lasts 120 days.
In Section 23,
Mr. Burke.
starting on line 24.4, there's an important clarification to help ensure that families and other interested persons are informed about significant events in the life of a person under guardianship. Guardians must file an annual well-being report with the court, but what happens if the person under guardianship is hospitalized for a heart attack and needs to be hospitalized for several days? Currently, there's nothing in the law obligating guardians to inform family members or other interested persons. And there are many examples where loved ones simply don't know that a person under guardianship has had a significant adverse health event. So the changes in this section lay out 3 specific situations in which a guardian must inform interested persons about the event unless they are otherwise prevented from a court order. These include a sudden or unexpected change in a health condition, a significant situation requiring the involvement of law enforcement or emergency personnel, or, of course, if the person under guardianship passes away.
Mr. McLeod?
Thank you, Mr. Chair. Section 24, line 25.28 is language that clarifies a court-appointed guardian or conservator can petition the court to be discharged from that appointment. This is not the same thing as being removed by the court. This simple provision allows guardians who have faithfully executed all their obligations to request the court to discharge them from the guardianship responsibilities. This is an important due process protection for the guardian and conservator, him or herself, as there have been examples of when people served as guardian and never got discharged, and they're still under court supervision, and they've been done for years. So it's just a clarifying thing that we can wrap things up and close the file.
And Mr. Chair, last one. Sections 25 through 37 of the bill make a lot of similar changes to the conservatorship statutes. Conservatorships are put in place when a person cannot make financial decisions for him or herself. So, for example, the same less restrictive alternatives language is inserted for petitions and for court orders. The same language that Bob pointed out about the filing of documents consistent with a bill of particulars is added. And in Section 39, we now would allow conservators to petition for a restraining order in the instance that we so often see these days of financial exploitation or other predators trying to take advantage of people under conservatorship. Obviously, there are several other sections that we did not go over, all of which are either updating or clarifying current law. We're happy to speak to any of those as we stand for questions. Thank you.
Thank you, Mr. Burke. Are there any other testifiers you have, Representative Muller? No. Okay. We will move to questions, but is there anyone else from the audience or the public who wishes to be heard on House File 3391? Can we amend this as amended? I see no hands. Okay, questions. Chair Scott.
Thank you, Mr. Chair. And just one quick question to the bill's author, well, perhaps to your testifiers that are at the table right now. You mentioned the time limitedness of this guardianship being 6 years, and I'm just wondering how you arrived at that number, and if any opposition exists out there right now for that provision.
Okay, Mr. Burke.
Mr. Chair Scott, thank you for that question. You did pinpoint an area that was a robust area of discussion for all of the stakeholders. Some individuals wanted it a longer time frame. Others wanted it much shorter. And the 72 months really, if you work backwards from if an individual gets guardianship at the age of 18, then after 6 years at the age of 24, it would be examined again. And then one more time potentially after that. That really creates 2 pauses in their life from ages 18 to 30, 12 years in which we know. Think about how your life changes in that. Everyone settled upon that as what we thought was a reasonable way to, again, stop unnecessary guardianships without creating too much of a burden for other individuals. I would say we as a coalition have not heard anyone specifically pushing back and demanded that be changed. The discussion has always been robust and one where an understanding that there's trade-offs for both sides, and this is a reasonable compromise.
Thank you, Chair Scott. Chair Considine.
Thank you, Mr. Chair. What?
Sir, go ahead. I skipped over Albright, but we'll get to him eventually.
Okay, thank you. Actually, my question is for Jean or her mother. First, I'm really pleased that this is working out, and Jean, as the chair said, you did a really nice job testifying. I'm curious, as Jean is working towards independence, do you utilize home health aides, personal care attendants? Is that part of the plan right now for her to be independent?
Ms. Hall?
Thank you, Chair and member. No, right now she, all her supports are natural through her transition. She still is attending a school, and then just through family.
Thank you.
Thank you. Thank you for coming back and answering the question. Representative Albright.
Thank you, Mr. Chair. And this would be to either the testifiers, but I'm looking at the section 16, subdivision 16A. It refers back to subdivision 7 under interested person. And I'm keying on 3.25, which says supported decision-making means assistance from one or more persons of an individual's choosing. And the definitions on page 2 with regard to the people that will be applicable to that. And my first question is, once the individuals are chosen, are they identified to anyone so that no one can kind of say, well, I'm a person of interest, so I have an opportunity? So what I'm trying to say is, does the individual subject to guardianship choose and then that's it, or does that list change from time to time?
Mr. Burke.
Mr. Chair, Representative Albright, it's a good question. Stepping back a half step, I do think it's important to distinguish between the definition at 3.24 of supported decision-making and the definition of interested persons, which is already in the statute. Those are two very separate things. So when you're looking at line 3.25 in a supported decision-making arrangement, think of that as its own universe. And in fact, what Jean or Eric or others did is they went to an attorney and talked about, just like you would in a healthcare directive or a power of attorney, who are the people that you trust to help you make decisions? And that's where that conversation of those people comes into play. So I haven't seen Jean's documents, but a typical supported decision-making agreement that's attached to a healthcare directive will explain to who's ever looking at the healthcare directive, this person, has so-and-so diagnosis, this is who they've chosen to help them make decisions, they are not under guardianship, this is a valid healthcare directive, and then you can use that to go get healthcare and treatment. That's already happening in the world, and the desire of this definition was simply to capture the universe of those types of arrangements. That whole process is separate from interested persons, which is a very defined set of people in the statute, so that in the guardianship process, there is a due process laid out there, and people who may be interested in the case are essentially given notice and saying this is happening. So I would really separate those two concepts.
Representative Albright.
Thank you, Mr. Chair. That's very, very helpful. So then to my question, because you've clarified it, is then, will the people involved in that supported decision-making process, can they change over time?
Mr. Burke.
Mr. Chair, Representative Albright, sure. Of course. And in fact, one of the most exciting things for advocates in this space is to watch what happens over the next 15, 20, 30 years, just as all of us change who our support networks are. They go from our family, our friends, our brother and sister, to eventually potentially our partner and spouse and others. The same type of thing can happen as a person under a supported decision-making arrangement changes as well. And they have the cognitive ability and the capacity legally to go back and change those. Yes.
Mr. Albright.
Thank you, Mr. Chair. One final question, and I'm going to follow up on Chair Scott's question on page 16 with regard to the threshold for the 30-year-old and the 72 months. So let's say that guardianship was enacted at age 24, and let's say the individual is now 26 or 27, and they have had a marked improvement or change in their situation. Is there an appeal process existent in law or in this that would avail that person to remove guardianship from the situation?
Mr. McLeod.
Thank you, Mr. Chair, Representative Albright. The answer is yes. At any time, any person under guardianship can petition to have the guardianship modified, to have the powers changed, or to have the guardianship terminated altogether. And on an annual basis, people who are under guardianship are given a notice that they have the right to do this. And in fact, under these statutory changes, we're expanding those notices of rights. So each year, a person under guardianship is given notice of rights, and part of those rights is the ability to petition to terminate the guardianship, or to change the powers, or modify it, or change the guardian. All of that is always on the table at all times.
Thank you, Mr. Chair.
Representative Robbins.
Thank you, Mr. Chair. I just have a couple questions. First, regarding the interested persons definitions, aside from the requirement that these people are communicated with, is there any other sort of rights that they have? I'm particularly interested in why the stepchildren were involved. I know that can be very contentious, and so I'm interested how that will play out. Thank you.
Thank you, Mr. Chair, Representative Robbins. Interested persons, the focal point of a guardianship proceeding is to make sure the court is fully informed. And interested persons is distinguishable from interested parties. An interested party as a point of law is someone who has a vested interest or stake in the outcome of the proceedings. An interested person is someone who's given notice and otherwise allowed to participate in the proceedings, not because they per se have specific rights, but because they may have information that may be very helpful to the proceedings. And as such, sometimes those interested persons are clipped from the proceedings, not allowed to pursue any further or otherwise. Now, they might have other rights under other law, but the point is they're given notices because they can offer input and provide input. Adding stepchildren is, the hard part in this proceeding is it's just not safe to assume that who an adverse person is. Very often the stepchildren are the closest people they have in their whole lives. Very often they've been raising the stepchildren as their own children, and they're as much of a parent to that person as anyone in the world. And they wake up to find themselves not getting notice of a proceeding when this person is more dear to them than anyone else. So it's sometimes with some weird notions, we sometimes feel like some people are adverse when they aren't. There's always opportunity for someone to object and to be adverse to each other, but in a court proceeding that is managed. And also, once the spouse dies, however, the stepchildren element ends. So if they're no longer a stepchild if they're no longer married.
Mr. Robbins.
Thank you, Mr. Chair. And also a second question regarding the 6-year term between people who are 18 and 30. I understand and am sympathetic about why that's important for people. But for people who their their capacity will not change. Does the family, so I know families in this situation, and do they have to go and re-petition for full guardianship at 24 years and 30 years? Because that's a very involved process. And it seems for families where there's clear incapacitation, that's a significant burden for them to have to go through that again 2 more times.
You want to take it, Mr. Burke?
Mr. Chair, Representative Robbins, it is a very good question, and it speaks to the conversation I was having with Chair Scott as well. A couple of points to be made. First of all, it's not just that they have to prove incapacity. Remember, there's 2 elements of a guardianship case. They also have to prove that no less restrictive alternatives work. And if anything, supportive decision-making in its development over the past 15, 20 years has showed us that this alternative way to make decisions and have legal decision makers help you out has been an amazing asset for a lot of young people and older people as well. And so what this process is really doing is not just looking at capacity, but it's also really forcing our entire system to look at those alternatives, something that's already in our statute. So that's one. Number 2, in those many of us think those cases will be more rare when it's really obvious, because the difference, again, between an 18-year-old and a 30-year-old, even people with significant disabilities, can be drastic. And so in those cases where it is more obvious, the family, having done the petition once, will have already now gone through it a couple of times. And so a lot of their work, their paperwork, the filing, it's potentially not going to change a whole lot. And so, again, taken all together, the cost-benefit analysis and the burden, while there in some cases, is going to be greatly outweighed by that pausing and second look to make sure that no less restrictive alternatives exist.
Any other questions from members of the committee? Chair Liebling.
Thank you, Mr. Chair. And Representative Mueller, thank you for working on this. And just one question, forgive me if I missed this, but have counties been involved in this process at all? And do they maybe not need to be? Just, things, I've been well trained by my county to always ask that question.
Mr. McLeod.
Thank you, Mr. Chair. Representative. The court system was kept informed throughout the system, and they've had representatives who've been a part of the system or part of the process, and we've provided them the information on an ongoing basis. And to my knowledge, they've offered no objection, to my knowledge. So we've been keeping them informed, but to my knowledge, we have no objection from them.
Mr. Burke.
Mr. Chair, Chair Liebling, the other thing to just kind of briefly note is counties can be petitioners. They sometimes are, especially in difficult, vulnerable adult cases where an individual is being abused, and they may use guardianship actually as a protective proceeding. But again, as Bob just mentioned, no objections, and also them going through, they would go through the petitioner process just like anyone would if you're a petitioner.
Chair Liebling.
Well, thank you. And so no objections, but have they been affirmatively involved? Have they been affirmatively informed? I mean, I know they do track things, but, this is, these are pretty big changes.
Mr. McLeod.
Mr. Chair, Representative, I guess the counties per se, no, but the courts, yes. It was a large group, but I don't think we had anyone who was per se from a representative county attorney's office of some sort or other. I don't recall anyone of that sort.
Thank you. Chair Liebling. Is it okay? Well, this is going to Ways and Means.
Chair.
And
Sorry.
it's
Got
not
another
Ways
answer
and-
coming.
I see it coming. Okay, I'm tracking here. It's going to Ways and Means, and you sit on Ways and Means. So between now and then, maybe they can have a affirmative answer on county. Mr. Burke. Okay. All right. Any other comments or questions? Then Chair Mahler moves that House File 3391 as amended be recommended to be re-referred to Ways and Means. All in favor signify by saying aye. Aye. All opposed say no. Motion passes. The bill as amended is re-referred to Ways and Means.